If you haven't complied with the Corporate Transparency Act by January 1st, 2025, you're looking at $500 a day in fines, up to $10,000, and as much as 3 years in prison. But here's the kicker. This law might actually increase your privacy if you do it right. Intrigued? Stay with me, and by the end of this video, you'll know exactly what to do because I've cut the fluff and stripped this down to a quick bullet point to save you time. So what is the Corporate Transparency Act? The CTA is a bipartisan law aimed at combating serious crimes like money laundering, human trafficking, drug trafficking, and the law requires U.S. corporations and LLCs to report beneficial ownership information to FinCEN. And that's the Financial Crimes Enforcement Network, a department of the U.S. Treasury. So what does this mean? Every U.S. company must disclose who owns and controls it. And the goal is to track bad actors hiding behind shell companies. The result? More paperwork for 99.9% of us who are law-abiding citizens. Whereas I'm not a fan of it. I think it's just a bunch of busy work. We all have to comply just like we have to pay our taxes. So why does this law exist? The stats behind it. Nearly 2 million corporations and LLCs are formed in the U.S. annually. In many states, you can set up an LLC with just a name, no ID, no ownership details, nothing. For example, picture this. A cartel sets up an anonymous LLC, launders millions through it, and then dissolves the company before law enforcement even knows it existed. And this, they say, happens thousands of times a year. The CTA aims to stop this by requiring every business to self-report its owners. But here's where it gets messy. If you don't file, even by mistake, you're still on the hook for penalties. Okay, so who needs to file? Existing companies must file the BOA reports starting January 1st, 2024, and you must comply by January 1st, 2025. New companies. If you start a company after January 1st, 2024, you must file within 30 days of formation. Changes. Any updates like a change in ownership or address must be reported within 30 days. What you need to report. For companies, full legal name, trade name or DBAs, business address, jurisdiction of formation, tax ID numbers or TIN. For beneficial owners, the full legal name, date of birth, residential or business street address, a government-issued photo ID. So who's exempt? Not everybody has to comply, but exemptions are rare. Large operating companies, 20-plus full-time employees, and $5 million in gross receipts, with operating presence in the U.S. Inactive entities formed before January 1st, 2020, no assets, no income, no operations since 2020. So who else needn't comply? Publicly traded companies, already subject to federal reporting requirements. Fun fact, even if you're exempt, you still must file a report stating which exemption applies to you. Penalties for non-compliance. If you intentionally don't file, it's a penalty of $500 per day, $10,000 in fines for non-compliance, and up to 3 years in prison for intentional non-compliance or providing false information. Now, here's some real talk. Imagine explaining to your cellmate that you're in prison for not filing a BOI report. That's not a conversation you want to have. The filing process, what to do. So now you gather your information for each beneficial owner. You'll need their name, birth date, address, and ID. You'll file online. FinCEN's online portal will be your go-to for filing. Update regularly. Any changes of ownership, control, or address must be filed within 30 days. Here's something you might find surprising. Why this law improves privacy. So here's a little twist. While the law collects your data, it also protects it. So who can access your BOI data? Law enforcement with proper authorization. Federal agencies representing foreign law enforcement and financial institutions only with your consent who can't access it. Civil litigants, snooping creditors, or nosy competitors. Now here's a hidden opportunity. Like when I pay taxes, I like to kind of look on the bright side. I say, hey, I'm paying for the radar that protects us from the bad guys and so on. So if you think it's just a bunch of busy work nonsense like I do, but we have to do it anyway, here's how to think about it. It gives you an opportunity to clean up your business structures. Most business owners have at least 1 or 2 dormant LLCs or corporations they've forgotten about. So the CTA is the perfect excuse to audit your business entities, eliminate unnecessary state fees, and streamline your asset protection strategy. For example, one of our clients discovered they had 12 inactive LLCs still racking up state fees. And here's a way around it that you may not have thought of. Offshore companies. That's what our organization does, is we set up a lot of offshore companies. And as long as they're not companies that also do business in the US, they don't have to report. So you can have an offshore company that has an offshore bank account, and you still need to pay your taxes, but you don't have to do the BOI for them. The CTA only applies to US entities. Offshore companies, offshore corporations, offshore LLCs are exempt. So this is a big benefit with offshore companies: greater privacy and also greater asset protection from lawsuits. So here's a pro tip: use offshore entities for legitimate purposes, like holding international investments. In fact, I have an offshore stock brokerage account that I hold in my offshore trust. We have thousands of clients who have offshore companies and offshore bank accounts. So for those of us who have corporations and LLCs, you don't want your cellmate asking, "What are you in for?" and having to respond, "Forgetting my BOI report." So doing this is kind of like airport security. Annoying, yes. Necessary, also yes. During COVID, let's say you started a side hustle selling cookies. Guess what? That LLC needs to file a BOI, even if you haven't used it for a while. So why are many upset about this law? Critics argue that this law burdens small businesses unnecessarily. 99.9% of the businesses affected are law-abiding, while only 0.1% are bad actors. So in reality, the good guys bear the cost of compliance, while the criminals often find ways to avoid detection. The positives? Greater privacy protections. Despite extra paperwork, the CTA includes strong privacy safeguards. Unauthorized disclosures of BOI info can lead to $250,000 in fines and 5 years in prison, even stricter than Swiss privacy laws. Now, you can still use nominee officers in public filings, like we offer nominee officers and directors, so your name doesn't show up in the public records. Our company does that as long as it's a law-abiding company, you're a law-abiding person, and that keeps your name private. So here are some FAQs about the Corporate Transparency Act. Do I need to file if my LLC is dormant? Yes, unless it qualifies as inactive. No assets, no income, no activity since 2020. What if I forget to file? Penalties start at $500 a day, and ignorance is not a defense. And this is especially if you do it and it's on purpose. Can offshore companies bypass this? Yes. Offshore companies are exempt from BOI requirements. So here's the conclusion. Take action now. Audit your entities, clean up unused LLCs and corporations, and file your BOI report. Ensure compliance by gathering the required info. It's really simple. And filing through FinCEN. You can get help. If this feels overwhelming, we're here to help. You can do it yourself, but we can also file it for you for a cost if you need to. So you can visit us at assetprotectionplanners.com or call us at 954-400-1050 to set up an offshore company or to have us help you file the BOI. Stay compliant, stay smart, and subscribe for more updates. I'll see you in the next video. And remember, the best asset protection starts with staying on the right side of the law.